Seth and Richie, thanks for joining me today. The State Public Defense Act made it through Senate committee. I believe it has yet to get a vote on the floor. This would be a total overhaul of the state public defense system. Seth, walk me through some of the changes that'll have for the counties.
Yeah, thanks, Ruth. So this is actually something that my organization has been working towards for over a decade now. We strongly believe that if you look at case law, if you look at the state constitution, that public defense is a state responsibility. To this point in time, that responsibility has been delegated to the counties, and each of the 44 counties is currently providing public defender services either through the direct employment of attorneys or through contracting with contracted criminal defense attorneys to represent those who have been accused. And so this is a significant shift from the way public defense is currently provided. Essentially, the bill provides for the establishment of a regional-based public defense system in Idaho that will be overseen by the state. So within each of our 7 judicial districts, there will be a chief public defender appointed who will oversee public defense within that judicial district. Again, rather than the counties doing that, it will be the state that will have oversight. The governor's office will appoint a state public defender to oversee the provision of public defense in the state of Idaho. And so, for the counties, again, it's relieving the counties of both their financial and also their other obligations in providing public defense, so that the state will assume all of those responsibilities.
What is the price tag with the state taking over those responsibilities?
So currently, as we look at what the county expenses are, counties are budgeting upwards of $36 million a year in county tax dollars. In addition to that, they receive $12 million in pass-through funds from the state of Idaho. And so the bill itself is a follow-up actually to House Bill 735 from last session, which established the funding stream for public defense. And in essence, the first $36 million will be dedicated and come from sales tax collections at the state level. The other $12 million that's currently appropriated by the state to pass through to counties will continue to be appropriated. So there will be $48 million there on the table. Now, I think there can be a debate as to whether that's enough to meet the state's needs. I do think that the legislature has the ability to appropriate additional funds. And a good example of that, counties used to administer on behalf of the state the catastrophic health care program. And for individuals that didn't have insurance, we would cover those medical expenses. The county would pay a portion of that and the state would pay a portion of that. Very rarely did the amount appropriated by legislature meet the needs of the program. And so each year the legislature would come in and pass a supplemental appropriation, paying the necessary bills to make sure to make sure the indigent medical claims were met. And I see public defense much the same way. I mean, the state will have to defend all of those cases, and if there isn't enough money appropriated initially, the legislature is going to have to come in and pay those bills and appropriate sufficient funds.
Richie, the ACLU of Idaho has long taken issue with the public defense system in the state. Can you walk me through some of your concerns with this bill?
Certainly, yes. Well, Seth is definitely right. The courts have made clear that it is the state's responsibility to provide public defense. And what we have in this bill is a bill that's going to continue the crisis that has existed since at least 2010. The state could no longer pretend in 2010 that the house wasn't on fire. And we filed suit in 2015, and what we've seen since then is only turning a little bit of a hose on that system. We are now shifting from a county-focused system under this bill, if it's enacted, to a state-based system. But we have a number of problems that this bill will just perpetuate. One of them is independence of the public defense function. And it's tomorrow, actually, March 18th, will mark 60 years since the landmark Gideon versus Wainwright case from the U.S. Supreme Court, which made clear that while a fair trial may not be essential in some other countries, it is in ours. And the way you ensure a fair trial is you build structures in between those entities that are prosecuting people, those people that are hauling people into the state's courts, and the people who are providing that defense. Before, we had that controlled by the counties, by county elected officials at the county level, and now we will have that controlled ultimately by the governor, the same executive branch that is prosecuting folks and that is holding people in its jail. So we have that independence problem. As Seth alluded to, we still have, under this bill and the funding mechanism underlying it, a major funding problem. Public defenders all across the state are doing outstanding jobs against impossible odds, against impossible workloads. We know approximately what those workloads are. We know that they seem to be getting worse, and we know that public defenders do not have the time, do not have the resources that they need. And so even the $48 million that Seth is talking about, while this state continues its addiction to prosecution, its addiction to incarceration, is not going to be nearly sufficient to give those public defenders a fair fight in court.
Richie, I want to ask you, so not everybody has had a public defender. Not all of our viewers are familiar with this system. What does it mean when the public defender's caseload is too high? What does that mean for the defendant?
Right, and it's an excellent question. One thing we should all recognize that when we talk about public defense, when we hear the term indigent defense, we're really talking about probably most Idahoans. If you found yourself in court, if any of us found ourselves in court tomorrow and we couldn't afford the thousands of dollars that it's usually going to take for an attorney, for investigators, for experts, for testing and other resources needed to defend these cases, that means we're probably going to have to turn to the state to provide that. But having a public defender means that you have somebody who knows what's going on in the court and who can connect you with the resources to defend your case. And just like housing in Idaho and across the country, even groceries across the country are unaffordable. Legal services are unaffordable to most of us as well. And so this bill really, and the public defense system in Idaho, really casts the structure that will either give us justice in our courts, give us a fair trial, or not. And we haven't had that for over a decade now, and this bill's not going to change that either.
Ruth, can I add a little bit to the separation of powers issue,
Sure.
or political independence, I should say. Right now, when you look at a county-based system, the county is both prosecuting and defending. One of the advantages that I see in this is that while the counties will continue to prosecute, we won't be responsible for the defense side. And I will say, because I've been involved in a lot of discussions as it relates to the bill that ultimately came to be, there were a lot of changes made to this bill to address some of the concerns regarding political independence. For example, the selection of local judicial district public defenders is insulated from the governor's office. The magistrate commission, which is comprised of citizens, will select who that judicial district public defender is. And then as it relates to the governor's office, yes, the governor will ultimately appoint who the state public defender is. However, the names from which the governor will choose will be recommended to the governor by a committee that's established, and there will be one representative from each of the 7 magistrate commissions who will recruit those individuals and recommend them to the governor. And so I do think there were efforts undertaken to try to provide some protections there. I know that if you read the text of the bill as well, that the state public defender, most state employees are at-will employees. In the case of the public defender, that position will be a for-cause position. And so I do appreciate the concerns about the governor appointing, but I think we've tried to address that in the bill to provide some level of protection to prevent some of that undue political influence.
But this is an important point, because I have heard throughout the progress of this bill the phrase, "Don't let the perfect be the enemy of the good." But whenever I hear that, I realize there's a profound misunderstanding of what the stakes are here. We are talking about fundamental human rights on which our system of justice depends. And so the perfect is being the enemy of the good is not at issue here. What we have here is the political compromise being an enemy of individual constitutional rights and personal liberty.
I want to talk a little bit about parity. You mentioned prosecutors earlier. We have about 5 minutes left, so we're going to have to keep it short. County prosecutors will still be elected, and they will still be on the county payroll. Is there a concern with the counties about parity between what those public defenders will be making and what the prosecutors will be making? How will that be addressed?
Absolutely. We have heard from our county commissioners in particular on this issue, because ultimately the county commissioners are responsible for approving and implementing the county budget, how those tax dollars will be spent. And this has been an ongoing issue, frankly, as long as this has been on the table. What we find is, if you give public defenders a raise, the prosecutors will seek a raise. Once they get a raise, public defenders will seek another raise. And there has been concerns raised by county commissioners that moving public defense to the state level, the state now will be funding defenders. And there has been concern raised as to whether the salaries, for example, of public defenders will outpace the salaries of prosecutors, and then will that require the county to levy more in property taxes to meet higher salary demands of public defenders, or excuse me, of prosecutors?
Is there a guess yet, or?
I guess time will tell, certainly, and it is a competitive marketplace right now for attorneys in general. It's a very competitive marketplace. I think public defender offices and prosecutor offices around the state are facing the same dilemma of being able to retain attorneys when you can go into the private sector and make so much more money.
Richie, the class action lawsuit that the ACLU has been supporting, Tucker versus Idaho, is set to go to trial next year. What does this change, and or if anything, we'll start with that. What does this change?
Right. I mean, I think unfortunately, even though there were times during the progress of this bill that I felt that we were so close to the finish line that I thought that the legislature and the stakeholders involved would let this bill get to where we could resolve this litigation and move on for Idaho, but we didn't get there. And so I think the case will continue on. Ultimately, a court's going to have to rule on this, and that may come as soon as the hearings that are set both for later this year and trial set for early 2024.
What more would it take to get there, though?
Well, I think we certainly need more money. If the prosecution levels are going to continue as they are, it's going to cost a lot more to make sure public defenders have the resources that they need. Now, another way that the state could address that, which even suggested by the U.S. Supreme Court, is to take a lot of the lower level crimes that public defenders are spending their time on out of the criminal courts and address them in other ways. So decriminalization could lower that price tag for this legislation. But we need more money. We need greater separation, even though the magistrate commissions are involved. The magistrate commissions are largely dominated by county level and local level elected officials. So we've got to create greater separation there. We need to tie Idaho more directly and clearly to national standards, because we don't have adequate Idaho standards to make sure that public defenders have the workloads that are manageable for them.
Briefly, Seth, do you want to weigh in on whether the magistrate commissions are politically influenced?
Yeah, well, and I think a broader issue that I think I want to address is, well, one, to get to your point on the magistrate commission. It is, again, it's comprised of county commissioners, it's comprised of mayors, it will also be comprised of defense attorneys. And these are all people who are in the communities. And I think I give them the benefit of the doubt, knowing many of these county commissioners that serve on the magistrate commission, that they are truly going to find the best attorneys they can. And if you look at some of the institutional public defenders around the state that have been selected by county commissioners, they're some of the top defense attorneys that you're going to find. So I have confidence in our local magistrate commissions. I also want to point out quickly that one of the unique aspects of this bill is that it creates a transition team which can help with any of these dilemmas or issues that pops up between now and implementation.
I'm going to have to leave it there. Thank you, gentlemen, for your time. I really appreciate it.
Thank you very
Thanks.
much.